I'd like to introduce Roby. Rose is very active in the Green Party on the Pinellas level, on the state of Florida level, and on the national level. I myself am LeBeau Kpadenou, and I work with the state and Palm Beach County level. Rose, as you know, I recently, this past weekend, quit my job because they tried to slip in a mandatory arbitration clause under the radar on us as we returned to work from the COVID-19 pandemic. And when I discussed this with you, you told me you had a little bit of experience with dealing with these. So why don't you tell us first what you can about what your experience is in dealing with mandatory arbitration clauses and mandatory arbitration?
All right, well, I worked 10 years for what was once the NASD, the National Association of Securities Dealers, and eventually became FINRA, the Financial Industry Regulatory Authority. And I will say, when they changed the name, I wondered why they wanted to sound like a prehistoric shark that was like some kind of sci-fi movie. FINRA, you know, coming for you. But I sometimes wonder if that was even an accident. There was something about that name that made me go, you know. But I worked for dispute resolution. And dispute resolution was the arbitration and mediation wing of the NASD. So let me tell people a little who the NASD and FINRA, what they would become FINRA are.
Please.
They are the regulatory authority. So they are the police of the securities industry, and they are the securities industry simultaneously in a lot of ways. They are like the police policing themselves. It is all, you know, it's when you see, you know, the police are doing their own oversight. That's really, it came out of the Great Depression. That's how the NASD was created. It was, okay, well, we need some kind of regulation. And that's what birthed the NASD. And that became FINRA. And so it's self-regulation in a lot of ways of the securities industry. Now, working for dispute resolution, I will say that people who worked there, we never fully understood it. And eventually I came to understand, why could everybody else who worked within this organization, there were a lot of departments, why could they could get jobs within other departments? They could move. If you were in good standing, if you got good reviews, you could find another job if you didn't like your department, or you could make more money somewhere else. With dispute resolution, we could never move within the organization. They would not look at our resumes. We were immediately cut out. And I think a lot of us didn't understand it. Like, what is it? What's so horrible about us that we can't get other jobs? And I think because we were hidden. We were this very hidden, we were the most brazenly unconstitutional section. We were, when you do business with the securities industry, when you want to invest, you're going to sign a mandatory arbitration agreement. And you can't do the business if you don't do that. So you can't take your broker to court. You can't do it. You got to go through us. Or, well, not us anymore, but them. You had to go through them. And I think that the reason we were so sort of despised and humiliated the entire organization was because they knew that this was something you kept under wraps. And that made all of us kind of dirty. So no matter how well we were doing within our jobs, and I'll tell you, when I was with them until, you know, stuff fell apart rather spectacularly in ways I can't get into right now, you know, for reasons that have to do with those contracts. Remember, Mike Bloomberg talked about those contracts that women so willingly signed. We willingly signed. Oh, you just want to sign those contracts. No, there is a gun at our head with those contracts, proverbial gun, and we sign them, and then we got to stick to them no matter how little it really was, and how, you know, but you want the pain to end. But
let me throw a couple of questions at you here.
What's that?
So we've established your bona fides. So you've worked on the inside. So give people an idea of what they're signing away with the mandatory arbitration clauses and what, if anything, they're getting back.
You're signing away your right to a court trial. You're signing away the public nature of a court case. Arbitration, mediation, these things are done in private. They are done in a way that, you know, it's all under the board. You tend to be working with your judge, will be an arbitrator who is associated with the very industry that you're going up against, who's paid by that industry. So, you know, I know they had in arbitration, they had public and industry arbitrators. And yesterday I had, you know, it's been 12 years, so I had to look up some stuff. And now I noticed they changed the name to non-public. And it wasn't industry arbitrators. They're just not public. We're not saying they're industry. I noticed that in the 12 years since I've been there, they've done some clever things with the language now. It's just not public. But you know, within any arbitration agreement, so you're signing away a lot, and you're signing away your constitutional rights. And I wish I could give you the name. But there was a Supreme Court case.
91.
Yeah, that allowed this. That this was challenged, and the Supreme Court said, "Nah, go ahead, and these people don't have constitutional rights. We, as the Supreme Court, have determined that." What are you getting out of arbitration? If it's not mandatory, there are some advantages to it. The advantage to it is that it moves quicker. So if you ever saw the movie Erin Brockovich, okay, she sells them on arbitration, but they had a choice. They weren't being forced into it. And her sales pitch for arbitration is, there are people who, you know, there was a court case, might have been around 3 Mile Island, I'm not sure, but where, you know, 20 years have passed and nobody's seen a penny. This is how long they've managed to drag out this court case. So do you want to take a chance on arbitration because it'll move quicker, it'll be more, you know, so that there, in that respect, it's not like there are no advantages to it. But once you take away that choice, that is a dangerous thing, and it's hidden in so many contracts, and people don't know it. I remember once taking out a loan. Let's say I was in my early 30s. I was working for dispute resolution, and they mentioned, "Well, you're signing a mandatory arbitration clause. We could explain that to you." And I looked at them and said, "I know what this is. You're taking away my constitutional right to a court trial. And I know exactly what it is because I'm in this business, because I need the loan, I'm going to sign it." You know, and I did, but there was sort of I know what this is. I know it.
So one thing that I noticed in our arbitration clause that we were offered is that it was basically in perpetuity and all points in the past. So I've worked there for 13 years, and if I, you know, signed this contract and discovered that they were stealing my wages for the first 5 years, I still can't go back and sue them, even though I wasn't under the contract when that happened. Is that common?
Yes. This is a sweetheart deal for the industries that, you know, in your case, so this is the restaurant industry. Like, this is a sweetheart deal for business. I'll tell you another case where it became very prominent was a case against Halliburton. Raped, and it was a rather horrific story, and kidnapped. It was, again, this was a while ago, but she was forced into a mandatory arbitration clause that ultimately the case became so public they had to get out of, that they couldn't force her to go through, and then she lost in court. You know, it was very sad. The stuff they do to rape victims, you're crazy, you're this, you're that. And it was all very sad. And there were actually some anti-arbitration forces that were on her side and then turned on her rather viciously. That, you know, you were supposed to be a good example for us and then you weren't. So to hell with you. But
Now,
that's how far it can go.
I do want to make it clear that, this Halliburton case is notwithstanding, and rape is very rarely successfully prosecuted in our society, unfortunately, this arbitration clause would not shield them from criminal liability. If they did something that was actually a crime, I could still go to the cops, right?
I have to look into this, but look at in the restaurant industry, because as it turns out, I also have some experience in the restaurant industry. I went to culinary school. I got it. It's a field where I got into it too late in life to really be able to do what I wanted to do, because the physicality of it I couldn't quite take. But the restaurant industry is just replete with sexual harassment and abuse of women employees. I mean, that's so much part of the scene. I'm not going to give names, but I would hear stories when I was in school. Now, I was 40s, which made me like 100 in that industry. But the young pretty girls, the 18-year-old girls, 19-year-old girls, they would get job offers from very famous chefs and told, you're expected to entertain him. And that would be flat out told to them.
Yeah.
So that's how much
what are you going to do
in the industry. And
so
open secret.
That goes to some of the things I've been reading. I read a report by the Economic Policy Institute. They did a little research on this, and we're now at a point where the majority of at least large employers are implementing these. But one thing you find is that basically the more female, the browner, the lower earning that your industry is, the more likely that you are to be under these clauses. So, like the average is 53% across all industries, but in construction, which is a very white male dominated, it's like 35%. And to me, that's kind of like a double victimization, because, if you're a white male, then there's a whole slew of, issues that you may have with your employer that are not going to apply to you. Like sexual harassment is very uncommon going in the other direction. Racial discrimination is very uncommon going the other direction. So if you're a white male, the rights that you're giving away, they're the same rights, but they're much more likely to be executed. They're much more valuable to people who are in vulnerable communities.
Yes.
I guess
Well,
I'm just speaking, but please speak to that.
Yeah, that's part of what this is. I mean, white supremacy and misogyny is so woven into everything. It's woven into the fabric of this nation. And we go, we need to come to terms with that. And I think we're at a moment where maybe more and more people are coming to terms with it. But the more vulnerable you are, the more they can screw you over, the more they can put you in a position, because let's put it this way. So you're being forced into this mandatory arbitration, and you're, thank God, in a position where you can make this stand. But if you are a poor woman of color and you have children and you have, you're barely getting by, you're going to say yes, or it's a good chance you're going to say yes. And what you're having taken from you, but you have to do it because that's survival. So that's so much part of how this stuff works, is the more vulnerable you are, the more they can hand you a contract and say, sign it. And, contracts are supposed to be two sides know exactly what, and there's an agreement, and we're making a contractual agreement. I'm doing this in exchange for that. I'm signing my name because but the reality of what contracts are is that so many times that, like I said, the proverbial gun to your head. You've got to do this,
And we have a right to work in our Constitution.
No.
We have right to work in our Constitution, and I haven't really done the research on it, but I'm getting the vibe from the people that I talk to who know about these things casually that, like, if you refuse to sign this and they let you go, then you were fired with cause, or you quit and you can't even get unemployment. I don't know that to be a true fact. I'm not a lawyer, not giving anyone legal advice, but it wouldn't surprise me if that was what I'm hearing about that is true.
Now, one piece of advice I would give people, although they can still get in trouble for doing it, which is sad, but one piece of advice I would say, you can sign your name and write the word signed under duress under that. That is actually something people can do with contracts. And will it ultimately work in your favor? I'm not here. First of all, I'm not an attorney. Second of all, I'm not here to tell you whether that will or won't. I can tell you that there were things I signed on to when things were falling apart spectacularly at my job, where when I was made to sign some stuff that basically was you're a liar and a horrible person, and I signed my name and wrote the word signed under duress under it. And ultimately getting any relief that helped that I had done that. So it's something people should know about.
That is a great piece of advice, and that's exactly the kind of thing that I'm happy to have you here for. So I've read, and I want to ask you two things and get your opinion on them. I read that if you're in mandatory arbitration with your employer, you're much less likely to win than you would in the courts. And I've read that if you do win, you're much less likely to get paid out, or you'll get paid out less than you're likely to make in the courts.
Yeah, absolutely. If you do win, they're supposed to pay you. They don't have an appeals process in this either, but your award will likely be considerably less than.
And I've heard from as a result of that, and maybe you don't have the inside expertise to know this, but that it's very difficult for employees under mandatory arbitration to find attorneys to carry out their arbitration clauses for their arbitration process for them, because the attorney knows that you're less likely to win and the payout will be much less. So if you can't pay him all the money up front, or her, then they won't take your case, meaning that you are much less likely to ever bring a case on something like wage theft or sexual harassment or those kinds of things.
Absolutely. Look, attorneys, if you watch TV, attorneys love justice. They just love it. They're all excited because they're going to get justice. Well, in real life, attorneys love money. And I'm not saying this. This is not the attorney. I'm saying that at law, if you largely look at the big picture of it, if an attorney doesn't see a sure thing in front of them, they tend not to like to take the case. They tend to be very conservative. And so arbitration, they're seeing less of a chance of a winning hand here. And when they're not seeing a winning hand, then this is not enough money in it for them. They're not like, I must do this justice. Most attorneys are going to be like, no money in this for me, or certainly not a guarantee. They like guarantees. Attorneys love cases where it's just so, obvious. I mean, I'll talk just a little let me go
Please.
On the issue of sexual harassment for a moment. Something that somehow, somewhere I know something about. If you come into an attorney's office and say, I was gang raped at my job and there's a video of it, what they're going to say is, yay, this is the greatest thing ever, yeah. But anything else, it's like, well, do you have, 20 other women who are willing to say this? Where's all your witnesses? They're not eager to take those cases, no matter how dirty they were handled, because they're not seeing that guarantee. There's this idea, and I think it really is pushed in propaganda. There's an idea with doctors, that doctors, like house, they come to your house to find everything that they can, and lawyers love justice. But under this capitalist system, people just want to move things along very, very quickly. Move it along, and if there's in law, they want that guarantee. They want to know that there's almost a guarantee. So yeah, arbitration, that stuff really does hurt your chances of being able to find an attorney who's willing to take your case. So what, you're left on your own. It's a tremendously dirty secret in this country, and I'm glad you're bringing it out. I keep wanting to say over after I speak.
I hear you.
I don't need to do that.
From our many meetings we have as a group, we use that. We say over when we're done talking, so that people will know when we're done speaking. All right. I think that you've done a great job at covering all the bases and letting people know what's going on out there. As you pointed out, mandatory arbitration is allowed because of a Supreme Court decision. So that would have to be overridden by actual law from Congress. But I do hope that we can, as we get the word out, that people will not stand for it anymore. So many people at my job, the way they handled it was so dirty. First of all, they gave us a piece of paper that basically, I don't remember the exact language on it, so I don't want to be held liable, but I do know that it had the phrase open door on it. implying to me and to many who read it that what we were getting was an open door policy. And the way that was described to us led me to believe that that was what was being described. But I saw at the bottom of the fine print about giving away constitutional rights, et cetera. And I'd heard of mandatory arbitration before, and so I didn't sign it. But so many people signed it, not knowing what they were signing and just giving away, their life. And, it's not even just about the fact that, like, they can't sue me for things in the past, but they know that it's nearly impossible for us to sue them, so they can just start doing things in the future and be like, catch us and do something about it. They can just decide to start skipping wages because now they have this protection. Because what are you going to do about it? What lawyer is going to come and and defend you for or represent you for the $3 an hour that they were taking from you or whatever it was,
Yeah, and I will say one other thing on this is that this truly isn't a sexy subject. It isn't a subject that the left brings up a lot. It's not in the public eye. What was I saying in the beginning? We were the dirty secret.
Mm-hmm.
We needed to be they didn't want people to know about us. And it's not an issue that the left takes up. I think it's important that you're bringing this out there, because part of how we're going to have change is we have to start making it part of our narrative, that the ways things are diseased and misogynistic and racist and classist, this is part of how they do it. People get excited about constitutional rights when it comes to freedom of speech, freedom of journalism. I'm not against that, but here's this way the Constitution is constantly being broke. It's being broke with the permission of the Supreme Court, and people aren't talking about it. And I think that it's got to be talked about now. People got to bring this out because there's too many people who are victimized by this, and too many big corporations who get to do these kind of things with impunity. And it's time for the Green Party should be part of the leadership on that. Absolutely.
And it really is especially insidious as it moves into employment. When I first read about it, I think the New York Times did a big write-up on the subject, and they were talking about things like phone contracts. And even then it was insidious because it's like you discovered that AT&T suddenly just charged every customer they have an extra $35. Well, you can't do a class action lawsuit. Are you going to get a lawyer to get your $35 back? But AT&T has millions of customers, so they have made a bunch of money off of that. And what are you going to do about it? And that's bad enough. But now you bring it to employment, a place where you're going to spend a third of your life at, half of your waking life at, and you have no rights, and there's no one you can turn to. It's take it or leave it. So I really do think that it's going to be up to us to engage in public education, public shaming, and like that should be an interview question when you go in and apply for a job. That should be an interview. The question you ask your interviewer, like, am I going to have to sign any kind of forced arbitration rider? Because I don't do that, or you're going to pay me a bunch more money, if you want my talents. So I do want to thank you very much for your time. I appreciate that you're very, very busy with the campaign, running a committee on the national level, sitting on the board at the state level, and co-chair at your county level. But I really appreciate you taking the time out to talk this through with me, and I hope that our green audiences will find this information to be useful.
Thank you, LeBeau. I appreciate you inviting me to talk about this.
All right. You have a wonderful evening, and I will talk to you soon. Thank you so much.
Okay, you take care, LeBeau. Bye-bye.
Bye-bye.